see and hear you.
All right, so that.
You'll see that the signal goes through.
So I'm
If you want, Your Honor, we'll pull out the private attorney case and the
Yeah.
child 10 case for us to do that for you.
That's fine. Okay.
Totally confused. Okay. You want to do those last, or?
No, these are just the risk assessments that go along with
Oh,
your magistrate docket.
Oh, okay, I got you, thank you.
I don't need to tell you which one is going to be the media one.
Okay.
It's the one to find your clip. And then this is the private attorney one. I'm going to go get the name of the private attorney.
Okay,
So
great,
I'll have it.
thank you. Okay. Let's get started on the juvenile, okay? Wait till the light comes on, okay. All right, good morning. We're first going to call the juvenile docket. When your case is called, please come forward. If you're with your parents should come forward as well. While you have the right to address the court, you should understand everything's being recorded and you need to be respectful at all times, failure of which could result in a contempt of court hearing. Public Defender's Office is also present and you need to speak to them before you speak to the court. All right, first is Kenneth Barana. Come on up.
Good morning, Your Honor. Spanish interpreter present for the mother.
All right, good morning. Brown is charged pursuant to probable cause affidavit, possession of burglary tools and burglary of an unoccupied structure. Court's reviewed the probable cause affidavit, is also charged with grand theft, resistance with violence and without trespass. Court's reviewed the probable cause affidavit, finds this probable cause recommendation by the department. Parent present in the courtroom? Is the parent present in the courtroom? Okay. Mom, the department has recommended that he be on what's called home detention, which means he's in the house. He's not out in the front yard, not out in the backyard. He has to be in the home for 21 days. And yeah, all right, and Kenneth, you understand what that means? You understand that if you don't do that, I have a place called a detention center where it's not with mom and the cooking's not half as good.
No problem.
All right, Kurt goes along with the department's recommendation.
And his next court date is July 17th at 8:30 before judge involved. All parties notice. Yes, at 8:30.
All right, thank you. Marcus Knighton. Marcus has been charged pursuant to a probable cause affidavit, one count of robbery by sudden snatch and one count of child abuse. Court's reviewed the probable cause affidavit. Finds probable cause. Their recommendation by the department.
The recommendation is up to 41 days of punishment.
All right, good morning. Ma'am, are you the mother?
Yes, sir.
Good morning. The department has recommended that the court impose what's called home detention for the next 21 days. Do you understand what that means? Okay, is that something you can enforce? Okay, you understand that means he's in the house. He's not in the backyard, not out in the front yard, he's not running around. There's no going out and playing. You understand? Okay. Marcus, you understand the obligations?
Yes, sir.
And you understand what happens if you don't?
Yes, sir.
Okay, you understand I have a detention center and that's where you would end up?
Yes, sir.
Okay. Court goes along with the department's recommendation.
And his next court date is July 27th at 8:30 before judgment. All parties. Yeah.
I don't think we have any.
Okay, we have an order to take into custody, a diligent search. Court will enter the order.
Yeah, you folks are good to go.
Yep, all set, thanks. Worthy also, court
Your Honor,
finds.
is it okay if I bring the rest of the parties inside?
Yeah, because I'm just gonna
Okay.
take care of these orders to take into custody. Here's the pickup orders. Beautiful. Well, and yours to match. Yeah, beautiful.
No shelters. We're ready to get.
Yeah, please. Thank you.
Okay, now everyone.
Here's your orders. Good morning. Welcome to First Appearance Court. I'm Judge Bowman.
I have more of these.
All right. When your case is called, please come forward so the court may address you. A couple of things. Throughout the course of the day, the court may offer plea agreements. Before you accept any such plea agreement, you should consult with the Public Defender's Office, understanding that if you are in fact in the country illegally, such a plea might result in your deportation, and also additional pleas may result in additional penalties. You're advised to consult with counsel. Court's going to call first Jacques Menelace. Hopefully I pronounced that properly. Come on up.
Good morning, Judge. Douglas Rudman on behalf of Mr. Manelis.
All right, good morning. Mr. Manelis has been charged pursuant to a probable cause affidavit, one count of battery to-wit domestic. Court's reviewed the probable cause affidavit, finds there is probable cause. Counsel, how do you wish to address the court?
Your Honor, at this point, I have spoken with the State Attorney's Office. The State Attorney's Office has said that they're recommending a $10,000 bond on this case. Respectfully, Judge, I would ask the court to impose a $5,000 bond on this case. No contact, no weapons. Your Honor, I would turn your attention to the probable cause affidavit. There is an allegation of 8 slaps. However, the only injuries that were found were to the victim's right side of the face, and it was only slight redness and swelling. Minor injuries and left forearm scratch, Judge, given the nature of the allegations and the, I would say, minimal physical evidence to support the allegations of the victim. We're asking for $5,000, no weapons, no contact.
Thank you very much. State want to say anything?
Yes, Your Honor. Good morning. Carice Grant for the state. Your Honor, it's not minimal. It's 8 slaps, 4 inside the home, 4 outside. He followed her outside the home and continued to attack her. There's also allegation that this has happened in the past. She just did not file it, and for that we're concerned. So the state's seeking $10,000. No victim contact, no weapons.
Brief rebuttal, Judge?
I'm good.
Thank you, Judge.
All right. I agree. Bond's going to be set at $5,000, no contact, no weapons.
Thank you, Judge. Have a good day, sir.
All right, thanks. Thank you. Juan Urbe.
He's in Maine, Your Honor, while they're getting him up. It's Mr. Carball, but just so.
Oh, okay.
You know.
Carball.
So for Mr. Carball, he has informed our office and the public defender in Maine this morning that him and his family are hiring a private attorney. And so that attorney's not present this morning. So what I'm going to do is I'm going to ask if we could reset this for Monday so he could get his attorney of choice present. He has a no bond hold on an out-of-county warrant anyway, so he's not prejudicing himself. And so I'm just asking for this to be reset till Monday.
Okay, not a problem.
Mr. Nessler, what week of the docket is that, John? Page 21.
All right. Thank you very much. We'll be
Monday, AM?
set to Monday. Tracy Harnamji. North Broward.
Yes, Your Honor.
Good morning.
Good morning.
Ma'am, you've been charged pursuant to a probable cause affidavit, one count of battery to-wit domestic. Court's reviewed the probable cause affidavit, finds there's probable cause. Court sets bond at $1,000 and a no contact order, sir, ma'am.
Yes, sir.
I spoke to Ms. Hermanji this morning. First, I do want to ask for a photo order. She broke her clavicle yesterday during the incident, so my office wants to take photos of that. The only issue is that she lives with her father. That's the only family she has down here. The alleged victim is her boyfriend, who lives, what I'm told, immediately across the street. So it's separate residences, but from my understanding, it's right across the street. So I just want that to be clear, so you're not asking for any, like 500 feet or anything.
I didn't put 500, I just said no contact.
Okay.
You know.
That's fine. So you understand, Ms. Hormaji, no calling, no texting like we talked about, okay? All right.
Yes, sir. Thank you.
Okay. Lady Diana Diaz Olivares. May? Yeah, okay, beautiful. Good morning. Been charged pursuant to probable cause affidavit, one count of aggravated assault with a deadly weapon and one count of battery to-wit domestic. Court's reviewed the probable cause affidavit, finds there is probable cause. Bond is set at $7,500 on count 1. and 1,000 on count 2. There is a no contact order entered.
Your Honor, they do have a child together, a son that's 4 years old. He does live with Miss Diaz Olivares.
Okay, well,
The only person of Sunday.
there's no contact, so until such time as they work it out or come to something else, I'm not going to have that risk. So, okay.
Okay, understood, Your Honor.
Thank you. Nicholas Michusin,
North Broward, John.
North Broward.
Good morning.
Good morning, sir. How are you? Sir, you've been
I've been
charged.
better, Your Honor.
You've been better. Okay. You've been charged with 1 count of battery to it domestic. Court's reviewed the probable cause affidavit, finds there's probable cause. Bond is set at $1,500, and there is a no contact order, sir.
Yes.
Robert Satterfield. Good morning, Mr. Satterfield. You've been charged with violation of a domestic violence injunction. Courts find there is probable cause. Court will grant you bond at $10,000. There is, of course, a continuing no contact order.
Your Honor, if we could argue for something a little lower, he can live with either his parents or his friend in Pompano. He's lived here all his life. He works as a handyman himself. He's had a flight risk. He just asked the amount to be lowered.
Well, to be honest, the court was considering no bond since it was a violation of a no contact, and I would be well within my rights to do so. I was sort of giving him a break.
Okay, thank you, Your Honor.
All right.
If he does bond, Your Honor, could we get a monitor on him?
I'm not opposed to that motion.
Thank
Okay.
you.
All right.
Level 2 from the state, please.
Level 2, apparently. All right, thank
Thank
you.
you, Judge.
John Pierre. Mr. Pierre, you've been charged pursuant to probable cause affidavit, 1 count of battery to wit domestic. Of course, reviewed the probable cause affidavit, finds there's probable cause. Bond is set at $2,500, and there is a no contact order, sir.
Thank you, Your Honor.
All right, thank you. Brian O'Shea. Mr. O'Shea, you've been charged with 1 count of battery to wit domestic. The court has reviewed the probable cause affidavit, finds there is probable cause. Your bond is set at $2,500, and there is a no contact order, sir.
Your Honor, Mr. O'Shea collects disability. We could argue for some kind of pre-trial program. He's lived here his whole life, but he does have a limited income.
I don't know what might be available.
Your Honor, we have several levels of supervision. The first level is standard, where the generally needs to call in 2 times a week, and he'll report after any court hearings. Then we have GPS level 1, which is completely locked down. He's not allowed to go anywhere except for support and to meet with his counsel. Then we have GPS level 2, which allows the defendant to go to work, school, home, church, so on and so forth, but it will be scheduled. And we use a fixed monitor, but he doesn't have to have a schedule.
Well, it sounds like if he's on disability, then he's a level 1. He's not going to work. So I'd agree to that with a, alternate to.
Thank you, Your Honor.
Would that be GPS level 1, no bond necessary, Your Honor? Or
Correct, yeah, no bond necessary if he does that. David Fisher. Morning, Mr. Fisher. You've been charged pursuant to probable cause affidavit, one count of battery, two at domestic. Court's reviewed the probable cause affidavit, sets bond at $1,500 and a no contact order. Joel Casanova. Casanova, you've been charged pursuant to probable cause affidavit, one count of battery, two at domestic. Court's reviewed the probable cause affidavit, finds this probable cause, bond is set at $1,500, and there is a no contact order. Michael Dillon. Morning, Mr. Dillon. You're being held on an outstanding capias for which there is a no bond hold. Kevin Michael Campbell.
North Broward, Your Honor.
North Broward, thank you. Good morning, sir.
Good morning.
So you're being held on been charged with battery, two at domestic. Court has reviewed the probable cause affidavit, finds there is probable cause. Bond is set at $7,500 on count one, and then there is I believe an additional count where you have a no bond hold. Yeah. Yeah, right, okay, because I think that's a no contact order as well. Thank you.
All right.
7,500, no contact. No contact. All right, thank you, sir.
Mr. Campbell, I'm just asking for a photo order. He had injuries. We were able to.
No problem.
Thank you.
Thank you. Robert Fields. Good morning, Mr. Fields. Mr. Fields, you're being held on pursuant to probable cause affidavit on domestic violence. Court reviewed the probable cause affidavit, finds there is probable cause. Court sets bond at $1,500, and there is a no contact order. John Pollock. Good morning, Mr. Pollock. Mr. Pollock, you've been charged with probable cause affidavit, one count of battery, two at domestic. Court's reviewed the probable cause affidavit, finds this probable cause. Bond is set at $1,000, and there is a no contact order, sir.
Your Honor, if we could ask for some kind of pretrial release. He can't afford bond. He lives with his wife, who is not a party to this action. He's a floor installer and painter and has lived here for 55 years. We would just ask for some kind of program and no bond amount to be charged.
All right. I'm willing to entertain.
It's at your Honor's discretion. Usually the public defender would ask for the type of pretrial supervision they would like, but it's at the court's discretion.
Oh, well, I understand that. What's your recommendation, counsel? Yeah, he's working?
He is working.
He's working?
He works as a floor installer and a painter. He works for himself.
Okay.
So he does doing front work.
Okay. What's the recommendation?
Yeah, just pretrial release, non-ankle monitor, just where you can call in. Standard pretrial release, Your Honor.
Okay, I accept. Pretrial release.
Thank you.
No, still no contact, okay? You got it.
And that was our order for pretrial, Your Honor?
Yes. Owen Fowler. Morning, Mr. Fowler. Mr. Fowler, you're being held pursuant to a probable cause affidavit, for which there's probable cause for domestic violence. Court finds probable cause. Also, you have some additional no bond holds. Bond is set on the one count at least at $7,500. Of course, there is a no contact order as well, sir. The other counts are no bond. Douglas Rope.
Mr. Fowler, did you step on count one, Your Honor? I didn't.
7,500.
Okay.
Good morning, sir. Show up, you're charged with one count of aggravated battery on a pregnant woman. Court's reviewed the probable cause affidavit, finds there is probable cause. Bond is set at $10,000. There is a no contact order.
Your Honor, once again, we've asked for a pretrial program. He works from home, so I mean, if we want to do like an ankle monitor, but I would ask for standard pretrial release. He does own his home, and he has 2 kids that he lives with them. He works in collections and does have meetings with a plumbers union that he needs to attend. But he works from home right now, so he can be confined to that area.
Okay.
But he can't afford bond at this point.
That's unfortunate because bond is set at $10,000.
And Your Honor, just for the record, the victim has safety concerns for her and the other children in the home.
Hence the no contact order.
Thank you.
All right, thank you. Antonio April?
Sorry, Your Honor. Can we get a photo order on Mr. Rope?
Sure.
Thank you.
Rope, you're being charged with violation of a aggravated no contact order.
Who's this one, Judge? I'm so sorry.
Antonio April. Court finds probable cause on count 3. Thank you. Bond is set at $10,000. There's a no contact order. Count 4 is bond at 100.
Sorry to interrupt you, Judge. You can't locate that PC.
Last name spelling is A-P-R-I-L-E.
Thank you. Could you go back through the counts, please, Judge? Sorry.
Absolutely. 1 second. Count 3, aggravated stalking, bond is set at $10,000. Count 4, possession is $100, and there is a no contact order.
Thank you.
All right, got it? Thank you. Anthony Sims. All right, Mr. Sims, you had charged 1 count of battery to it domestic, a 2nd count of simple battery. Resistance without violence, and you have an outstanding VOP for which there's a no bond hold. Court sets count 1 at 1,000, count 2 at 1,000, and count 3 at 500. There is a no contact order. Obviously, you have a no bond hold, so. All right, thank you. Peter Dinnerman. All right. There's the reset. William McDonald.
Your Honor, he had family come by this morning. He has a private attorney, Brad Collins. I don't believe the attorney's going to be here this morning, but I believe what the family just wanted me to convey to Mr. McDonald is they're going to bond him out once bond is set this morning, but he does have a private attorney.
All right. All right, sir, reviewed the probable cause affidavit. You've been charged with domestic violence. Course refines there is probable cause. Bond is set at $3,000. And there is a no harmful contact.
Your Honor, I spoke to the victim of the case, and she stated that she has safety concerns in regards to the defendant for William McDonald.
And yet they want to make bond.
Who is family? I don't know who in the family, but there's someone in the family.
Not necessarily the victim, Your Honor.
Did the victim express safety concerns?
Yes, Your Honor.
Yes.
All right, I'll make that no contact.
What was the bond again, Your Honor? Sorry.
3,000.
Thank you.
I'm sorry. Nicole Cooper.
Yes, come on.
No problem, John.
Thank you. Cooper, you're being held on an outstanding capias in the amount of $100. Court is willing to offer you a plea. If you'd like to resolve it today, the offer is an adjudication time served.
Okay, that's fine.
Do you want to accept that?
Yes, sir.
You understand that you're giving up your right to go to trial, you had the right to go to trial, you had the right to have an attorney, and you had the right to have the state prove all those charges, and you're giving that all up. You understand that?
Yes, sir.
All righty. Court accepts your plea. Adjudication, time served. All righty. Thank you, ma'am.
All right, thank you.
Kelly. 6 months. You guys are getting me on both sides here. Kelly Michelson. Good morning, Ms. Michelson. You've been held on an outstanding capias. The bond has previously been set at $100. The court is willing to make you an offer. The offer is an adjudication with time, bless you, time served.
Thank you.
Do you want to accept that?
Yes, I do.
You understand you're giving up your right to go to trial, you have the right to go to trial, you have the right to have an attorney, and you have the right to have the state try to prove all those charges, and you're going to give that all up. You understand that?
Yes, sir.
Okay. Court will
I
accept.
will be released today.
It's a time served, so yeah, you're done
All
today.
right. Thank you very much. I'm done.
6 months. Natasha Johnson. Johnson, you've been charged pursuant to probable cause affidavit, one count of grand theft, two wit auto. The court's reviewed probable cause affidavit, finds there's probable cause, bond is set at $1,000.
Your Honor,
Yeah.
the defendant is currently on supervision with pretrial services.
Okay.
Based on the court's finding of probable cause, we would ask that you revoke her supervision in case number 186149 CF10A. The charge was grand theft auto. She was placed on pretrial supervision on June 20th.
Court will revoke the prior supervision.
Will that be a no bond hold, Your Honor?
Yes. Patient Nawabo. Nawabo, you've been charged with probable cause affidavit, one count of trespass and one count of harmful conduct to a public servant. Bond is set on count one at 100 and 3,500 on count two.
Your Honor, if we could ask for standard pretrial release, Ms. Nwago. Then we would ask for an ROR. Ms. Nwago cannot afford the bond.
the
Nope.
court is aware, it appears as though Ms. Robert is living at a non-verifiable address. Does she have an address?
She's homeless.
Seems to be. I don't know.
If the state may, Your Honor.
Go ahead.
It appears she is homeless. This is the second interaction where she's had with this officer from the PC. She does have a tendency of being violent when approached. So we'd ask that the bond remain in place.
Is there some way the state could resolve it today? Any ideas?
Sure. We'd adjudicate her on both counts, put her on.
It's a
Actually-
felony, Judge. We can't resolve this today.
Oh, never mind.
But even if she doesn't have a verifiable address, if she's on standard pretrial, she has to check in. If she doesn't check in, she's going to be held no bond. She can go to any public library. She could use the phone there, make the call the clerk's office to find her dates. But she could be released to standard pretrial even if she doesn't have a verifiable address. It's her duty to check in and make her dates.
In addition, Your Honor, you can tailor the standard pretrial so that in addition to calling, she must physically come.
Yeah, I would want at least the phone calls and at least once a month coming
At
in.
least once a month coming.
Correct.
Your Honor, she's indicated that she no longer wants a pretrial.
I don't want pretrial. I never wanted pretrial.
Oh, okay. Okay, well, you have your bonds. Beautiful. All right, thank you. Angela Thorpe,
Yes, Your Honor.
good morning.
Good morning.
Ms. Thorpe, you're being held on a violation of probation, for which there is a no bond hold and a outstanding capias of $500 as well.
Switch over, Judge.
Oops, I'm sure it was North Power. There you are. So, all right, so you have a no bond hold and another one that's an outstanding $500 one. All right. Okay, thank you. Karen Marshall.
That's right, Your Honor.
No problem. Oh, hold on. Good morning, Ms. Marshall.
Good morning.
Ms. Marshall, you're being held on 2 violations of probation for which there is a no bond hold. You also have an outstanding petty theft for which there's a $750 bond. All righty, thank you.
Thank you.
Vanessa Basto.
She's fine.
Okay, thank you. Good morning, Ms. Basto. Ms. Basto, you're being charged pursuant to probable cause affidavit, 1 count of grand theft. Court's reviewed the probable cause affidavit and sets bond at $1,000. Tania Escalado Felix. Oh, okay.
She's at Paul Ryan, Your Honor. She will need a Spanish-speaking interpreter.
Who is present in the court. All right. Good morning, ma'am. Good morning. Ma'am, you've been charged pursuant to a probable cause affidavit
Señora, según la declaración escrita juramentada, a usted la están acusando
with aggravated assault with a deadly weapon.
de intento de agresión física con un arma mortífera.
Court's reviewed the probable cause affidavit
El juez habla, dice, he revisado esa declaración juramentada
and finds probable cause.
y hay un motivo fundado para detenerla.
Bond is set at $2,500.
Impongo una fianza de $2,500.
There's also a no contact order.
Y también hay una orden, perdón, de no contacto o comunicación.
And if, Your Honor, if I could just inquire, because I do not speak Spanish, I have not spoken to her.
Sure.
El señor abogado defensor aquí presente en el tribunal le pide al señor juez si se puede comunicar con usted a través de la intérprete debido a que él no habla español. Le quiere hacer unas preguntas.
Ms. Felix, can you afford a $2,500 bond?
Señora Félix, ¿puede?
25.
Sorry. Señora Félix, ¿usted puede pagar esa fianza de $2,500?
¿Completo?
The whole thing.
Do you work? Do you have any income?
Señora, permítame le pregunto, ¿usted gana un salario, trabaja?
Ahora no.
Right now, no.
Do you live on your own or do you live with family?
¿Usted vive usted sola o con familia?
Mi pareja.
With my partner.
I do not see any Broward priors. Would you consider releasing her to standard pretrial? I'm only able to see Broward.
El señor abogado defensor le dice al señor juez, yo veo que la señora Félix no tiene antecedentes penales, por lo menos yo solo puedo ver la parte del condado de Broward. ¿Podría, por favor, dejarla en libertad bajo los servicios especiales de la corte, los estándares?
State would object, Your Honor.
En la fiscalía habla, dice, objeciono, su señoría.
Court might consider a level 2 GPS.
She doesn't work, Your Honor. I don't see the reason why she would want to leave the house, so I'd ask for a level 1.
Okay.
Señor juez, habla. Estoy considerando si es que la dejo en libertad bajo esos servicios especiales de la corte con la condición de que sea a nivel 2. La señora fiscal habla, dice, señor juez, objeciono, debido a que usted no trabaja, no necesita salir de la casa, pido que la dejen en libertad bajo los servicios especiales de la corte nivel 1.
The only thing I would ask, Your Honor, is if you would waive the fee of the monitor.
El señor abogado defensor habla al señor juez. Señor juez, lo único que pediría es que por favor no la exoneren de pagar ese recargo por el monitor que le van a poner.
And state would object. She does live with her parents.
Pardon me, counsel.
State would object. She lives with her parents.
Thank you. La señora fiscal dice que ella objeciona debido a que usted vive con sus familiares, con sus padres y madre.
All right, I'll grant the level 1 GPS, no contact. I'm not waiving anything.
Your Honor, no possession of firearms, weapons, ammunition,
Correct.
and stay at least 500 feet from the victim.
Señora,
So we can map the GPS.
That's fine.
señora, el señor juez habla primero. La dejo en libertad bajo los servicios especiales del tribunal. Eso es el nivel 1 con un monitor que se llama un GPS. Se debe mantener 500 pies alejada de la víctima a todo momento. No debe poseer o tener en su tenencia armas de fuego o munición.
Okay. All right, thank you very much.
Gracias, señora.
Tricianda Shep. Thank you. Ms. Shep, you've been charged pursuant to probable cause affidavit, 1 count of battery on a person 65 years of age or older. Court viewed probable cause affidavit, finds probable cause. Court sets bond at $2,500. And there's a no contact order. Naresh Shanath
Yes, sir. Your Honor.
Conti, thank you.
Your Honor,
Yes.
there's a correction on that count two. It was supposed to be a $1,000 bond.
Oh, okay.
No bond.
Yeah. Good morning, sir. Sir, you have an outstanding capias in the amount of $1,000.
Your Honor, I spoke to Mr. Sanath this morning. So when this capias was issued, he was actually in custody on what's count 1. This is count 2. He's serving a county sentence. And so he's been in custody since May 1st. This capias was issued on May 8th. And so he was in BSO custody when this capias was issued. What I'm asking for is, Mr. Sanath, do you want me to ask for an ROR or do you want to resolve this today?
Yeah, I want to resolve, or
Your Honor, I'd ask you if we consider resolving this case today to time served.
Is there an offer from the state? I move with that.
But adjudication time served, sir.
thank you.
Oh,
Yeah, well, let me ask you a couple questions. You understand that you're giving up your right to go to trial? You
Yes,
understand-
sir.
You understand you have the right to have an attorney represent you, you have the right to have the state prove their case, and you're giving that all up. Do you understand that?
Yes, sir.
And it's an adjudication, time served.
Thank you, sir.
Okay. Maurice Watson? Good morning, Mr. Watson. You have some outstanding capuses, two in the amount of $500, and the third one's actually an ROR. We'll keep those.
Your Honor, someone could correct me if I'm wrong, but when I believe he came through yesterday on a felony charge and he was released a pretrial on that. And I'm guessing in that process they found these capuses. With that in mind, I would ask if you would consider releasing him to pretrial since he was released to pretrial on a felony. I believe it was yesterday, July 6th, from what I can see.
I don't know.
That's
He was.
Yes,
So sort of two things passing in the night, huh? Well, doesn't that affect the other one, though? Had they known about this, they might not have issued it.
But I would say, Your Honor, that was a felony, and they did release him to pretrial. These seem to be traffic citation cases. I'm not sure.
It's about the flip side of that coin is we can try to resolve them.
I would ask my partner in the jail. I don't know what his thinking is.
Yeah, if we could hear an offer from the state, he is interested in resolving these cases.
Okay.
I'd adjudicate on counts 2 and 4, withhold on counts 3, time serve on both count 2 and 4.
If I could just have 1 moment, Your Honor.
Okay. I'm going to ask you to go over that one more time. Oh, when they finish.
Yes, he would like to resolve it and accept the state's offer.
Okay, the state's going to repeat the offer one more time.
On counts 2 and 4, it's an adjudication, court cost, time served. On count 3, withhold court costs.
Sir, you understand the offer that's been made by the state?
Yes, sir.
You understand that you had the right to go to trial, right to be represented by an attorney, and right to have the state prove those charges, and you're giving that all up. Do you understand that?
Yes, sir.
All right. Court will accept the plea offer.
Can I go to work?
Okay, you're all set. Thank you. Anthony LaPella. Morning, Mr. LaPella. You're being held on 2 outstanding capuses, one in the amount of $2,000, one amount of $1,000. All right, thank you.
Your Honor, the 2003 case and the 2004 case, I don't know if my colleague was able to speak to him if he could afford that or not, but if he's unable to afford it, I would ask Your Honor if you would consider either pretrial or some sort of non-monetary release, that these are 15 and 14 years old, respectively.
State would object. He's been in KPS his entire time, Your Honor. He has a problem reporting.
Yep, I agree.
Your Honor, can I correct the case number, please, for count 2?
Sure.
Mr. LaPella would request a pretrial release program, just standard pretrial. They are misdemeanors, and they're 14 years old.
All right, thank you. Go ahead with correction.
03003 644 NN28.
Going to the court stands.
That was the bonds in place, correct?
Yes. Leonardo Olivia. Good morning, sir. Mr. Olivia, you are being held on pursuant to a probable cause affidavit for loitering and trespassing. Of course, good morning, sir. Of course, reviewed the probable cause affidavit, finds there's probable cause. Do you understand what's going on here today, sir?
Yes.
Okay.
Yes.
All right. Are you able to make bond?
I don't have $25,000, but
It's not.
I could,
It's $25.
oh, I don't have $25.
Okay. Court's considering making an offer to him. Is there any?
Adjudication, court cost, time served.
That's the offer. Sir, the court's willing to make an offer to you. It's an adjudication, time served, court costs. Do you want to accept that?
Yes, sir. I'll accept that.
Okay. You
I don't
understand?
want it.
Okay.
Right.
Listen to the following. All right. You understand you're giving up your right to go to trial, your right to have an attorney, your right to have the state prove all these charges. Do you understand that?
Yes, sir.
And you're asking me to go ahead and accept the plea, which is an adjudication,
Yes,
time served, so you've already
Yes,
done
sir.
the time.
Yes, sir.
And there's court costs, which I'll give you 6 months to pay, okay?
All right.
All right,
All right, thank you.
you got it. Timothy Odom. Good morning, Mr. Odom. You're being held on some outstanding cases for municipal violations, as well as a probable cause affidavit for municipal items. Of course, reviewed the probable cause after there is probable cause. Sir, do you wish to resolve this today?
Yes, sir, I do.
The court is inclined to offer you the following offer, which is an adjudication and time served. Do you wish to accept that?
Yes, sir.
Okay, you understand you're giving up your right to go to trial, your right to have an attorney represent you, your right to have the state prove all these charges against you.
Yes, Your Honor.
All right. All right, you're resolved. Kevin Yard.
Good morning, Judge. Jara McLawrence. I'm here from the City of Fort Lauderdale Public Defender's Office. I represent Mr. Yard.
Okay, good morning.
Good morning.
Mr. Yard's been charged pursuant to probable cause affidavit with 2 counts of violation of municipal ordinance, 1 an open container, and the 2nd possession of cannabis. I got a question,
Yes, Judge.
and it might be for the state. I got probable cause because I field tested it because it smelled that way. I've never seen a case that says that's field testing. Do anybody know? I mean, I sit over in the land of civil, so I don't read these too often. That was the first time I ever saw it, and I've been doing this for 15 years. Paragraph 2, about the 2/3 down. Marijuana cigarette was field test positive for marijuana by its odor, which based on my work, etc. And it may be so ubiquitous that that's good, but I have yet to see that in a case.
Well, based on his training and experience. And it's a city case, Your Honor.
I understand. Well, I'm going to decline to find probable cause on count 2. I don't know if you'll want to try to amend that or not. That said, I'm willing to make an offer.
Judge, he does want to resolve count 1, which is the open container charge. And I'd ask if the court would adjudicate in time served on that particular count.
Yes, I would. So, sir, do you understand that you, the attorney is, on your behalf, has requested that you want to change your plea? Do you understand that?
Yes, Your Honor.
Okay, and so do you want me to accept that? And you understand that if I do, you're giving up your right to go to trial, your right to have an attorney represent you, your right to have the state prove these charges against you, and it would be an adjudication time served with 6 months to pay any court costs?
Yes, Your Honor.
All right, court will accept. I don't, are you going to amend count 2? No, it's dismissed.
So, Judge, what are you going to do with count 2, Judge?
Dismiss it.
So, Kevin, the judge is letting you out today. Your case is resolved. You have my business card. If you want some assistance as far as finding placement and housing, just give me a call and I'll try to help you out at Henderson.
Thank you.
You're welcome.
All right, thank you.
Judge, I have one more. If I could just call out a turn.
Yeah.
It's on page 17 of the docket.
I got to go through the book here.
It's Derwin Robinson.
I got it. Okay, Mr. Robinson, good morning, sir. We have I have an outstanding capias, which bond has previously been set for $250.
It's for panhandling, Your Honor. I have the notice of appearance on that particular case if you'd like to see it.
Okay. I probably have it.
I don't have a probable cause argument as far as the panhandling offense is alleged, Judge, but I would like to, Mr. Robinson would like to resolve it if possible.
I'm okay with an adjudication time served.
He's fine with that too, Judge. Thank you.
Mr. Robinson, you understand changing your plea, you're giving up your right to go to trial, your right to have an attorney represent you, your right to have the state prove those charges against you. It would be an adjudication time served, 6 months to pay any court costs.
Thank you, sir.
Okay, accept.
Thank you, Judge.
Gary Altman. Gary Altman. There you go. Good morning, sir.
Morning.
Mr. Altman, you have a couple of municipal violations here. Probable cause for municipal violation of no OSHA-approved vest and no roadway safety course. Okay. So there's probable cause. The court can set bond at $25 or offer you a plea. Do you want to accept that?
You'd like to resolve it.
All right. So the offer is an adjudication time served, 6 months to pay any court costs. You want to accept that? All right, you understand you're giving up your right to go to trial, your right to have an attorney represent you, your right to have the state prove the charges against you. You understand that?
Yes, sir.
All right. Court adjudicates, time served. Jeremy Souza.
Sir.
Good morning, sir. So as you charged pursuant to probable cause affidavit, 1 count of petty theft, resistance without violence. Court reviewed the probable cause affidavit. You also have an additional, finds probable cause. You have some outstanding capiases. Bond is set on count 1 at 100, 500 on counts 2 and 3 each, and 1,000 on count 4. All right, thank you. Kenneth Thompson. Good morning, Mr. Thompson. Thompson charged pursuant to probable cause affidavit, 1 count of trespass. Court reviewed probable cause affidavit, finds there's probable cause. Bond is set at $25.
Your Honor, Mr. Thompson is interested in resolving this case.
Mr. Thompson, this is, would be the second time at the same McDonald's. I have a problem with that. So here's the deal. I would adjudicate you, I'd give you time served, but I'd also order you not to return to that McDonald's at any time. Understanding that that would be, you know, you could be arrested immediately. Understand that? You can't go back there ever again.
Yes, sir.
You want to accept that offer?
Yes.
Now, you understand you're giving up your right to go to trial, right to have an attorney represent you, right to have the state prove those charges all against you.
Yes, sir.
It's adjudication time served. I gave you 6 months to pay costs. And you are not to return to that McDonald's. That's the address. All righty, thank you. Tori Leonard.
Yes. No problem, John.
Thank you. Mr. Leonard, and you have an outstanding capias in the amount of $250.
Honestly, I didn't even know I had
Sorry.
the warrant, Your Honor.
Okay, hold on. Let me take a look at it then. Okay, I guess you wouldn't. Well, it's from 2012. That's what happens when you do that. All right. Would you like to try to resolve it today?
Yes, if possible, yes.
I'm willing to adjudicate time served.
He doesn't have any priors in Brown County.
And I would actually waive your court costs.
Your Honor,
Thank you.
If he has no priors, I'm only able to see Broward. But if he has no priors, I would ask for withhold and then just judicial notice of the time that he was in. Okay.
Offer stands as adjudication, time served. I'll still withhold the court costs because you've not had that problem in Broward. You want to accept that?
Yes.
Okay. You understand you're giving up your right to go to trial, your right to have an attorney represent you, your right to have the state prove those charges against you.
Yes.
All right. All right, you're all set.
Thank you. Thank you.
All right, have a great day, sir. Anthony Mastropolito.
No problem, John.
Oh, my. Good morning, sir. Good morning, sir. Sir, you have been charged with probable cause affidavit with trespassing. Court finds there is probable cause. And I would note this is the second time that you've been warned to stay away from this area.
Sir, I will not talk about the facts, sir.
Town. That wasn't the same
Sir,
place.
I will
Okay.
not talk about the facts.
Tell me to stay away from everywhere in Lord Embassy. They don't like me there personally.
Nope.
I'm 86 from everywhere, and I don't violate any of the places. This was the public bathroom, and I wasn't told that particular spot.
Okay. All righty, sir.
I talk to people on social.
That's fine. Social's good. The bond is currently set at $100. I'm willing to make you an offer. It's an adjudication, time served, and 6 months to pay any court costs.
Yes, that's fine. Thank you.
You understand you're giving up your right to go to trial, right to have an attorney represent you, and a right to have the state prove the charges against you.
Yes.
Okay? It might be a good idea to stay away from that city then. All right, you're all set.
All right, thank you. Have a good day.
You too, sir. Thank you. Maurice Rowland? Good morning, sir. Ms. Rowland, you have 2 outstanding cases, one in the amount of $500 and one in the amount of $1,500. And that's what they are. All right, thank you, sir. Charles Wiggins. Mr. Wiggins, you have 3 outstanding cases, one in the amount of $500 and 2 in the amount of $250 each. They are from a while back. Are you interested in trying to make a resolution, sir?
He is, Your Honor.
I'll ask the state if they'd like to make an offer.
Communicate on all 3 counts. Court cost, time served.
Okay. The offer from the state is adjudication, time served, 6 months to pay court costs.
Yes, he'll accept that, Your Honor.
All right, so you understand that if you do that, you're giving up your right to go to trial, right to have an attorney represent you, right to have the state to prove all the charges against you. You understand that?
Yes, sir.
All righty. So, accept the change of plea. Okay, you're all set. Thanks, sir. Larry Morrell. Morning, Mr. Morrell. You're charged one count of sleeping on the public sidewalk. Court finds probable cause. Bond is presently set at $100. Would you like to try to resolve it, sir?
No, sir.
Okay,
I
sir.
want a bond now.
Okay, bond is set at $100. Luis Jose Cruz.
Your
Sepulveda?
Honor, can we recall that one? He's in the holding cell. The deputy's getting him now.
Oh, okay, no problem. Christopher Williams. Morning, Mr. Williams. You're being held on an outstanding capias in the amount of $500. Driving while license suspended. Okay, that stands. Jermaine Harding. Good Morning, Mr. Harding. You're charged with one count of culpable negligence. Court's reviewed probable cause affidavit, finds probable cause. Bond is set at $500, and there is a no contact order with the victim. Gregory Moss. Good morning, Mr. Moss. You're being held on an outstanding capias in the amount of $250. Is there an offer from the state?
1 second, Judge.
Sure.
Adjudication court costs? Time served.
All right, sir, the offer from the state is an adjudication, time served, 6 months to pay court costs. Is that something you want to consider?
Yes, he would like to resolve the case.
All righty, sir. Do you understand if you accept the plea or giving up your right to go to trial, right to have an attorney represent you, right to have the state to prove the charges against you, it would be an adjudication, time served, and 6 months to pay any court costs. You understand that?
Yeah.
And you want to accept that? All right. Very well. You're all set. Thank you.
Your Honor, we have Mr. Sepulveda Cruz. He was the one that was in the holding cell.
There we go. Okay. So you've been charged one count of resisting an officer without violence, for which bond has been set at $100. You have an outstanding capias in the amount of $250. Is there an offer from the state?
1 second, Judge. Withhold on the KPS, Your Honor, and adjudication court costs, time served on count 1.
Okay,
If you could just have one moment, Your Honor.
sure.
He would like to accept this offer, Your Honor.
All right. So the offer is on count 1, resistance, an adjudication with time served. Count 2 would be a withhold. You understand, in 6 months to pay court costs. Do you understand that by accepting this, you're giving up your right to go to trial, right to have an attorney represent you, right to have the state prove these charges against you? You wish to accept this offer? Very well. Okay, you're all set. Thanks. Yvonne Vasquez. Good morning, sir. Ms. Vasquez, you're being held on outstanding VOP for which there is a no bond hold. Thanks, sir. Dwight Robinson. Sir, you're being held on outstanding capias in the amount of $100. Court's willing to make you an offer on that. If you want to resolve it, it'd be an adjudication time served, 6 months to pay court costs.
Yes, Your Honor.
Okay. Do you understand if you accept that plea, you're giving up your right to go to trial, right to have an attorney represent you, right to have the state prove the charges against you?
Your Honor.
Okay. I will accept your change of plea.
Time served.
Time served, sir.
All right.
The count one is a non-criminal citation. It's a traffic citation. That's what it really is. Yeah. No. Yeah. I wanted to see if you were paying attention. Okay. All right, we're going to take a 10-minute break for everyone to use the restroom and the like, and we'll resume in about 10 minutes, okay? Thank you. Or grab coffee or whatever you want. All right, well, set to go back again?
Yes, Your Honor.
All set, I got a public defender there. Ryan Robinson. Mr. Robinson, you've been charged with probable cause affidavit with criminal mischief, resisting without violence, and trespassing. Court sets bond at 100 on count 1, 500 on count 2, and 100 on count 3. Arbin Heisa. Trent Shirley. Reset again? It was,
Medical reset.
yeah, so it was the last time. Okay. Tyrone Solomon.
North Broward.
Thank you. Good morning, Mr. Solomon.
Good morning, sir.
Solomon, you've been charged with 1 count of battery on a person in a jail facility. Court reviewed probable cause affidavit, finds probable cause, bond is set at $1,000. Nathan Cole.
Frazier.
Nathan Cole.
I believe he's going to be a medical reset.
Medical. Okay. Medical, I guess. Vaughn Frazier. North Broward, thank you. Frazier, you've been charged with possession of a weapon by convicted felon for which there is no bond.
I believe Mr. Frazier, if we're here on count 2, he's entitled to bond on that count. It's not a punishable by life case. It just has.
Well, he's got a no bond hold.
He does have a no bond hold on count 1, but he's entitled to bond on count 2. And the only count on the docket is count 2.
Okay. We'll set bond at $5,000. Greg Tartar.
That still came on now, though, right?
He's in Maine, Your Honor. With Mr. Tartar, a couple of things. He wants to be represented by the public defender this morning. If Your Honor read the probable cause.
I got a conflict written on here.
So what our office wants to do, he wants to be represented by us for first appearance. So I'm going to ask Your Honor to sign an order appointing us for first appearance purposes only. That's what Mr. Tartar wants this morning. And then we're asking Ora Tennis to withdraw from the case given the conflict.
How do I see an obvious conflict?
He wants our representation this morning. RCC is not here. So we're okay with, our office is okay with representing Mr. Tartar this morning if that's what he wants. But we're going to ask to withdraw and have the office of RCC appointed going forward.
Okay.
But Mr. Tartar does want our services this morning, and we discussed this with him.
Okay. So you've been charged with 1 count of intimidation with a threat to kill or injure. Court finds probable cause. Bond is set at $5,000, and you are to have no contact with the victim.
Your Honor, Mr. Tartar would request a pretrial release. He has a wife at home that's blind and requires care. And she's having surgery again on Tuesday. He can't afford the bond. We would request pretrial release. He's disabled.
Okay. Court stands by its ruling. Thank you.
So what was bond set at, Your Honor?
$5,000. Damian Sewell.
Your Honor, Mr. Sewell, he's deaf, so there might be some issue. I believe his mom and sister are in court. He was able to read the probable cause affidavit, and we have been able to have some communication over here on this side with him, but I did want to bring that to Your Honor's attention.
Okay, in court. Ma'am, you want to tell us who you are? You can speak right there. What's your name? Could you pull that microphone down just a little bit? I want to be able to, so he can hear as well. And what is your relationship to?
I'm his mom.
And your mom, okay. Well, he has been charged pursuant to a probable cause affidavit with battery on a law enforcement official. Court finds there's probable cause. Without talking about any terms of the case, is there anything you want to tell me, ma'am?
I really don't understand how the court system goes, Your Honor, because I am just here to be of support to my son.
Support your son,
and I
okay.
just want the court to know that he is a person with disability and that he called the cops, you know, because that's what I instructed him to do because he has a behavioral issue, whereas he do work. He's been working for ever since we moved to Florida here.
Okay.
And he has a job coach, and things able to diffuse the situation, and so I'm just asking for lenience of the court.
Well, I'm not passing any judgment on guilt or innocence, but I will tell you, I'm a little concerned that according to the probable cause affidavit, he said I wanted to go to jail to get away from something. So I'm concerned about what's going on in the house.
He didn't, no, my home, no, nothing. He was amongst these three, my daughter and his girlfriend.
We won't go too far into the facts,
problem that's a misunderstanding, Your Honor. Let me tell you, because he always he grew up with an IP. His father been out of the home since I was pregnant with my daughter. His father is dead. I raised my kids not to be this kind of a product of this society, Your Honor, but to be a product of a good statistic, and that's why I instill in them. So I instructed my son that if he's around in a situation whereas he feels that it's going to get out of hand, call the police, and that's what he did. He's easily redirected because he has emotional outbursts and stuff like that. And he has, even during school, he had to have a one-on-one para. The job coach, he has a job coach. He works with Whole Food, been gainfully employed since 5 years now, no problem. So I don't know what it means when I say, but there's nothing. So he feels like he and this young lady here was having a misunderstanding, and he called the cops because he felt like, I don't know if it's not going anywhere, and that's what he's instructed to do. If there's a situation, call the police for help.
Okay. Well, he needs to make sure that he always does things in the right way. Bond is set at $500. All right. So.
Your Honor, if we could get that lowered just by a little bit, he did indicate that he'd be able to afford between $200 and $300.
I just moved.
The bond is, yes, the bond is $500.
Okay.
Thank you. All right, thank you, ma'am. Leonardo Mason. Good morning, sir.
How you doing?
I'm well, thank you, sir. You've charged pursuant to probable cause affidavit with multiple counts, burglary of an unoccupied structure, grand theft, battery on a law enforcement officer, resistance with violence, resistance, 2 counts without, and striking a police officer. Court's reviewed the probable cause affidavit, finds there's probable cause. Court sets bond at $10,000 on count 1, $750 on count 2, $500 on count 3, $1,000 on count 4. And we'll keep the bonds of $100 each on the remaining counts.
Your Honor, if we could request a photo order. Mr. Mason has visible injury.
Very well. Daniel Searles. Has been charged with multiple counts of possession of a weapon by a convicted felon, possession of cannabis, violation of probation, fleeing. On the possession of cannabis, court has a trouble with the probable cause. I don't know if the state wants to try to correct that.
That's count 11, yeah?
Count 11. I mean, it just says 2.5 grams, that's all it says.
I'm sorry.
Yes.
On count 12, that was booked as a violation of probation as if there was a warrant already there. It's actually a 9.806, and it's been corrected.
So is it still a no bond hold?
Yes.
Okay. Right. Court sets bond at $500 on each of the first 10 counts. The violation of probation, count 12, is a no bond hold. And 500 on count 13. If you wish. How long do you need?
48 hours.
Ronaldo Salas. Morning, Mr. Salas. Mr. Salas, you're being held on an outstanding VOP for which there is a no bond hold. Joseph Curtis.
No problem, Your Honor.
North Broward. There's Mr. Curtis. Good morning, Mr. Curtis.
Thank you.
You have 2 counts, 1 count with tampering with evidence and 1 count of a municipal ordinance violation. Of course, reviewed probable cause, find there is probable cause.
Your Honor?
Yes.
Based on the court's finding of probable cause, Mr. Curtis is currently on pretrial supervision in case number 186040MO10A. It's an aggressive panhandling charge. We would be asking that you revoke his supervision in that case. He was placed on pretrial supervision on June 28th.
Very well. We'll do so. Bond on count 2 is at $100. Count 1 is $1,000. And I will revoke.
And I would ask if you would set a monetary bond on that. It sounds like it was a municipal ordinance case.
I did, 100.
Oh, okay.
No, on the revocation.
The revocation.
Correct. Are you going to hold him no bond, or are you going to set a bond?
But that's what I mean, Your Honor. That's an MO case. I would ask for monetary bond. I don't want him to be held no bond on a MO.
$2,000.
$2,000. Thank you, Your Honor.
Thank you. Brandon Langford. Langford, you've been charged with 1 count of burglary to a vehicle. Of course, viewed the probable cause affidavit, finds this probable cause, bond is set at $1,000.
Your Honor, if we could ask for pretrial release or ROR, Mr. Langford can't afford the $1,000 bond. He is homeless at this time.
Motion is denied. Jesse Smith. Well, Mr. Smith, you charged 1 count of burglary of a vehicle. Of course, viewed the probable cause affidavit, finds this probable cause, bond is set at $1,000. You also have some outstanding warrants from other jurisdictions in the amount of $15,000, $15,000, and $2,000. David Chin.
No problem, Your Honor.
Thank you.
For the record, Your Honor, Mr. Chin refused my services this morning, so he's representing himself.
All right. Good morning, Mr. Chin. Mr. Chin, you've been charged with one count of burglary of a vehicle. The court's reviewed the probable cause affidavit, finds there is probable cause. Bond is set at $1,000.
Yes, sir.
All right.
Yes, sir.
All right. Have a great day. Thank you, sir. Daniel Marico. Good morning, sir. Sir, you have been charged pursuant to probable cause affidavit with 2 counts of battery on a person over the age of 65. Madam State Attorney, I really only see one count, I guess. Unless it, well, I see what they're trying to say. 2 people. Okay. 2 counts. Court finds probable cause. Bond is set at $1,500 on each count. And no contact. Raymond Trainer. Trainer, you've been charged with probable cause affidavit, 1 count of grand theft. Court's viewed the probable cause affidavit, finds there's probable cause. Bond is set at $1,000.
Your Honor, if we could also ask for a pretrial release. He's disabled and can't afford the $1,000 bond. Just ask for standard pretrial.
Roof coating. I don't know. State have a position?
Objection.
Okay.
We'll keep the bond at $1,000.
All right. Bond remains $1,000. Michael Goodwin.
He's coming, Your Honor.
Thank you. Mr. Goodwin, you're being held on a outstanding warrant for which there is a no bond hold. Stevie Maxwell. Morning, Mr. Maxwell. You've been charged with 1 count of possession of cannabis and 1 count of trespass. Court finds probable cause, sets bond at $100 on each of those counts. You also have an outstanding VOP, it looks like, for which there are no bond holds. Yes, indeed. Colin Cheatham.
Mr. Maxwell, Your Honor, I don't believe there are no bond holds. I believe they just have to be magistrated. I don't think they're.
Well, I saw the order.
This hearing.
Hold on.
Count 2 and 3 are hold for men.
Nope, there's a warrant. There's a warrant. It says no bond hold.
It's no hold for magistrate. It was a non-effective.
Oh, okay. They've got it as 2 counts here. Yep, okay. All right. 500 on each of those 2 counts.
They would ask for a $5,000 hold on each.
So failure to register.
Right, and then giving a false name to a law enforcement officer to avoid being detected for having not registered as a sex offender.
I'll grant up to $1,000. I'll grant you that on count 4.
Thank you, Judge.
You got it. Yeah. Mm-hmm. Yep. Colin Cheatham. Cheatham, I have you on a no-hold bond on 2 counts and looks like a $5,000 bond on a different count. Yep. No-hold bond. All right.
If you're going to hold him for count 1, and I think we have to make clear for count 1 on what the charge is that you're finding, I believe, because it has 2 different languages on there. I believe we have to make sure that it's going to be attempted murder if you're making a finding of probable cause on it. But beyond that, to hold Mr. Cheatham on no bond on count 1 of 2 things has to happen according to the 4th DCA. This cite, the case I'm going to cite to is Yasaza v. State, 222 Southern 3rd 3. Either the state can move for motion for pretrial detention, which they have not done this morning, or Your Honor has to make a finding of proof evident presumption great on count 1 in this case. The 4th DCA is clear that proof evident presumption great actually is beyond a reasonable doubt standard, and so the state would have to produce evidence that goes beyond a reasonable doubt standard today to get that hold on count 1. There is no objection to count 3. It's a violation of probation hold, so he could be held no bond on that. Count 2, Your Honor, set a $5,000 bond, but for count 1, it has to be one of those 2.
Let me ask you a question. Okay. I remember reading the case, and I thought that case was on a probable cause affidavit versus a warrant where it has been reviewed accordingly by a court. So
correct, but so I have no objection to probable cause because the affidavit, it's assigned more by a judge. I have no probable cause argument to the arrest, but to be held no bond, the court has to make a finding of proof evident presumption grade, so that's even a higher.
But what I'm saying is that has already been done by the judge who issued it.
When a warrant is
presumptively,
when a judge signs a warrant, in these situations, when it's basically an either arrest warrant or when it's a non-in-custody information, that if they sign it no bond, it's a no bond for magistrate. It's not a no bond hold going forward. Everybody, regardless of the charge, is entitled to their magistrate date. And so this would be Mr. Cheatham's magistrate date. That's different than when it's a capias for missing a court date. But in this instant, it's a no bond hold, so that means he had no convenience bond before showing up to magistrate this morning. For him to continue to be held no bond, either the state needs to file for pretrial detention or Your Honor needs to find proof evident presumption grade.
Interesting.
State moves to pretrial detention, yeah.
They're going to have 5 days to make that filing. That's what they're going to do.
Your Honor, based on the probable cause affidavit, there is evidence for...
there is probable cause.
Right, but the court could find that there's proof evident presumption grade from reading the affidavit and the circumstances surrounding everything and the warrant being issued for this. So I'd ask the court to consider and make that finding at this time.
It does appear to the court there is, in fact, proof evident. So we can go with the no bond hold, or at least.
And just to make it clear, it's for attempted murder, right?
Attempted, yes. Yeah, that's exactly what it is.
But just because sometimes the language they want to on the docket just ordering.
Thank you.
Thank you.
Oliver Jean Baptiste. Baptiste, you're being held on outstanding warrant for violation of community control for which there is a no bond hold. Eli Zephyr. Zephyr, he's been charged with one count of missile into a vehicle, to wit, a BB gun. Court reviewed the probable cause affidavit, finds there's probable cause. Court sets bond at $2,000.
We're gonna ask for a no victim contact, Your Honor. The car was occupied at the time.
Very well. No contact with victims. John Victor. You can hold pursuant to a number of warrants. One of which is for $100,000, one is $10,000, and you have some VOPs for which there are no bond holds. Donald Biggie.
Yes, sir, Your Honor.
With Broward, thank you. Biggie, you're being held on an outstanding warrant for which there is a no bond hold. Steve Gallen. Mr. Gallen, you've been charged with a probable cause affidavit with 2 counts of illegal use of a credit card and 1 count of petty theft. Court sets bond at $1,000 on count 1 and on count 2 and $25 on count 3.
Your Honor, we would ask for standard pretrial release on this. Mr. Gallen can't afford the amount that's been set. We would request that.
Well, according to probable cause affidavit, this occurred at work in an employee's lounge. I'd be a little hard pressed to understand that.
The state would object, Your Honor.
So the bonds remain as stated. Jason McLaughlin. Often you've been charged with 1 count of possession of cocaine, 1 count of drug paraphernalia. Court has reviewed the probable cause affidavit, finds there's probable cause. Is there an offer from the state?
No, Your Honor, it's felony on the count 1. We can't resolve it.
Bond is set at $1,000 on count 1 and $500 on count 2.
And Your Honor, if we could ask for a standard pretrial release, this is a first-time offender. Seems the 1 count of possession of a cocaine and the other ones doing misdemeanors and a municipal ordinance violation. If we could just ask for a standard pretrial or ROR for this, he can't afford the $1,000 bond.
Does he qualify? Okay. Is he working or not working?
Not at the moment. I have a side job, but it's not on the books.
I gotcha. What's just a standard pretrial release then?
It's calling in 2 times a week, and then generally after every court hearing, he'll have to come over to the pretrial office and meet with his assignment.
Okay, I can go with that. Isaac Lewis. Isaac Lewis.
They already bonded out, Your Honor.
Beautiful. Okay, thank you. Everton Duncan.
He also bonded out, Your Honor.
All right, thank you. Samuel Rivera. Mr. Rivera, you have you have a VOP, so for which there is a no bond hold. Robert Hummel. You're also being held on an outstanding VOP for which there is a no bond hold. Oh, that what you mean to say? I didn't know. John Hughes. She's been charged pursuant to probable cause affidavit, one count of possession of heroin, for which bond is set at $1,000. You also have some outstanding capiases for which there are no bond holds.
Mr. Hughes has indicated that he went to court on Tuesday, and they lifted the capiases.
Yeah, they gave me paperwork that said it might stop me from getting arrested, but I missed court on Monday. I went on Tuesday, Judge Merrigan, and they actually lifted both of the warrants in the courtroom. So
I don't know if that's shown up on our system yet. And let's see here. Well, that'll have to be set in front of Judge Merrigan. I'm sorry, I don't have it. Vincent Burgess. Burgess has been charged with probable cause affidavit, one count of grand theft auto, unlawful possession of an ID, possession of oxycodone, possession of cannabis, and drug paraphernalia. Court's reviewed the probable cause affidavit, finds there's probable cause. Bond will be set at $1,000 on count 1, $100 on count 2, $1,000 on 3, $100 on count 4, and $100 on count 5. Mikhail Johnson. Johnson, you've been charged with probable cause affidavit, one count of resistance with violence and one count without. Court sets bond at $1,000 on count 1 and $500 on count 2. Jimmy Lee Paulson.
No problem, Judge.
North Broward. Good morning, Mr. Paulson. Mr. Paulson, you're being held on an outstanding capias for which there is a no bond hold.
It was a change of charge, Your Honor. I believe it's a collateral change.
The thing about it, you gotta talk to some of the guys in the room.
Well, here's a nice question. One would seem to argue on that instance, based on our prior conversation, that he might be entitled to some sort of bond. Yes. However, I have no probable cause affidavit from which to make some determination about that.
So what I can tell you, Your Honor, is that there was PC found originally. The bond was set at $7,000. He originally, I believe it was, I think originally it was deadly weapon and it's been changed to bodily harm, but so it was from AGBAT to AGBAT. Originally it was set at $7,000. He's been in custody for 6 weeks. He's been unable to bond out on it. He's been in South Florida since 2006. I would ask Your Honor if you would consider putting him on some sort of pretrial with a GPS. Otherwise, he's going to just remain in custody. but originally there was PC found and the bond was set at $7,000. So if Your Honor is not going to grant some sort of pretrial release, I would ask for the $7,000 or something lower, but he has been in custody in 6 weeks on this case.
Well, in those 6 weeks, he's not made a motion to the presiding judge to say the exact same thing?
I do not know.
I don't know how to do that.
And if Your Honor would like
Oh.
a brief summary of the facts, I could give it.
Well, somebody pulled up the PC for
Oh,
me.
okay.
This is a great team I got over here. I like that. Wow.
But he had moved for, Your Honor, that they moved for ROR, and then on the 30th day, that's when the change of charge was filed, so that was the change.
We'll continue that $7,000 bond, which is probably better than what I would have done. But be that as it may.
No victim contact hearing?
I would assume that's already there. I don't know.
I think you have to order it again now, so. You did order no victim contact.
I would think
Just to be
not.
safe?
I'll do it.
Thank you. You said that was a $7,000 bond?
Isaiah Wynn. Same story for Mr. Wynn here.
Hold for magistrate, Your Honor, it's a misdemeanor. I believe it's an add charge, so I believe it's just count 3. Or no, you know what?
So it's a resistance without violence. Is that something the state can resolve today? Rather not. Okay.
This one was actually a down file, I believe. Originally it was resisting with violence. So it was a felony, and now count 3, it's showing that it's a misdemeanor, if I'm understanding the change.
Bond set at $1,000. Hakeem Newman.
Your Honor.
Thank you. Ooh, contact. There we go. Ta-da. Good morning, sir.
Good morning.
We have outstanding cases for burglary and attempted burglary.
So these are both filed cases. They were not in custody information, so this is Mr. Newman's first magistrate hearing on these cases. There is another count that's not before us today. So he's already in custody on a $2,500 bond. He's been in custody on that since June 6th, so a little more over than a month ago. Mr. Newman is 18 years old. He does have a stable address, but his family's been unable to post the $2,500 bond on a different account. I would ask Your Honor to consider either some sort of nominal bond on these or to put him on pretrial on these, and so he can move whoever his division judge is on count 1. But he has been in custody on a $2,500 bond on a different count for over a month.
Let's see, that is. Oh, they got both. They can take, the division judge can always review it, but I'm setting it $2,500 on each count. Well, if he's already on it, then, you know. Well, there you go. On each count, right. Arlindo Drek Cruz Jr. Oh, or maybe Duck Cruz Jr. All right, thank you.
I think you just Spanish-speaking interpreter. Are you okay?
You speak English, sir?
Yeah,
He's good.
yeah, I understand a little bit.
Okay.
I can handle it.
Okay.
But interpreters, that is better.
We do have one.
Thank you.
Sure.
Spanish interpreter present, yeah.
Sir, in charge pursuant to a probable cause affidavit,
Señor, según el affidavit o declaración juramentada,
burglary of an unoccupied structure,
lo acusan de entrada ilícita con fines delictivos a una edificación que no tenía ocupantes,
possession of burglary tools,
tenencia de herramientas de hurto,
and one count of grand theft.
una acusación de hurto cuantioso.
We also have an outstanding VOP.
También tiene pendiente una orden de quebrantación de una probatoria.
Court finds probable cause.
El tribunal encuentra o haya motivo fundado para detenerlo.
Sets bond on what's listed as count 12 at $5,000. Count 13 is $1,000. Count 14 at $5,000. Count 15, $1,000. VOP is a no bond hold. And count 18, $5,000.
Señor, impongo una fianza para la acusación 12, $5,000, para la 13ª acusación, $1,000, para la 14ª, acusación, $1,000, para la acusación 15ª, $1,000. No se le puede imponer fianza para la 16, para la acusación 16. I am so sorry, 16 was no bond and 17. 17 was no bond, right?
It's a no bond hold. 18 is $5,000.
$5,000 para la acusación número 18.
Joseph Retta.
Yep. Okay, gracias. Thank you.
Un momentico, señor.
Count 22. Oh, okay. Why did I miss that?
Un momento, todavía hay otras acusaciones.
I don't keep those bonds. Count 19,000, counts 20 is 1,000. VOP, of course, is no bond. Burglary is 5,000. Possession 1,000. Grand theft 1,000. Another VOP, no bond.
El señor juez continúa para la acusación, para la 19, $1,000, para la 20, $1,000. No le pueden imponer fianza para la quebrantación de la libertad vigilada, $5,000 para la. I'm so sorry, 5,000 was for the.
Burglary.
Para la entrada ilícita con fines delictivos, $1,000 para el hurto cuantioso. Y no se le imponen fianza para la última acusación, que es quebrantación de la probatoria.
Okay, gracias.
Okay.
Have a great day, sir.
Thank you. Okay. Now Joseph Retta.
No How you doing, sir?
North Broward. There you are. Good morning, sir.
Hello. How you doing, sir?
I'm not too bad.
Is this a reset from
Yeah.
yesterday?
It appears to be, because I have paperwork from yesterday, or the 6th, losing track of days. Okay. So you have two outstanding misdemeanors, capias in the amount of $500 each. And it looks like violation of community control, VOPs.
Yes, sir.
Which would be a no bond hold.
Yes, sir.
So we just need to give you a new date.
No, can I reside at misdemeanor?
I'm going to let the presiding judge resolve everything, sir.
All right.
All right. Have a great day, sir. Thank you.
Who's your judge? Who's your judge?
Okay. Earl Outlaw.
Medical research, Your Honor.
Medical.
Young.
Medical.
Yes.
Robert Young.
North Broward.
North Broward. Good morning, Mr. Young.
Good morning, Your Honor.
You've been charged with one count of burglary of an unoccupied structure and one count of grand theft. Court finds there's probable cause. Bond is set at $5,000 on count 1 and $1,000 on count 2. Okay, very well. Jawan Magwood. Good morning, sir. Magwood, you have a VOP warrant for no bond, I'm afraid. Rashad Mullane. You're being held pursuant to a warrant for which there is a no bond hold.
Two last names that just the two gentlemen we just did. Could I have the names?
Mullane and Magwood. That's all I got.
Please.
If somebody has anything else. As they say, is that a wrap? I think it is. Okay, thank you much. Everyone have a great day till tomorrow if you're all on my team tomorrow. Or if you're lucky not to, that's okay too. So you guys have to stay. You're wonderful. I love it. Okay, I'm going to exit out of this. I'm powered out.